Finish that little thought here. So we got men and women from all over the state of Michigan meeting every other Thursday, discussing and educating ourselves on common law. Common law is nothing but constitutional law, the people's law, and versus the statute. So Tom tells me we're ready to go. So with that, I'm going to continue with my prepared speech. The title of this speech, this presentment is Constitutional Declaration of Public Servant Status from the Common Law of the People, setting in our Common Law Court of Record. Kind of lengthy, but you'll see where we're going with that. Good day, and thanks for the opportunity to share the combined research of several of my closest friends and myself. We have all been at our research for the better part of the past 20 years. This research is focused on both the state and federal constitution and several of our state's statutes. Let me say right up front that you'll hear me repeat this several times throughout this report and the 5 or 6, 20 to 30 minute reports to follow. I know you're all happy to hear that. The federal constitution is the supreme law of the land, and it sets the standards for which each and every state constitution must follow to be admitted into the several states. Anything that purports to be a statute is by its very nature a limited set of regulations or rules that cannot be inferred to make everyone liable. And the proof will be presented later in this talk. It is my intention to challenge most of everything that you have been told and or led to believe about what is law and what is legal and what the difference is. I don't have the time or resources here to do a deep dive into this area. It is enough to say that once you have the basic overview of what this presentation is going to show, along with an open mind, that there will be more than enough resources given to you to do your own research and prove or disprove this presentation. I love to be challenged. So bring on your evidence when we get to the question and answer area. So what did you just hear me say? I said I am going to challenge your current thought on what the law is. Law is something that does not change. It is the same for each and every one of us. The law of gravity, God's law, is one of these. It affects each and every one of us the same. Number 2, our federal constitution and each state's constitution that have passed the test of not conflicting with the federal constitution is deemed to be the law of the land. Finally, that every statute, whether it is federal or state, is subservient, that is, under or below the Constitution. They are less than the law of the land. Where there is a conflict between the Bill of Rights and the federal or state statutes, which one do you think prevailed? If you believe the statute has more authority, then you are in a large group of similar thinkers, but wrong. I know. I'm sure with some thought, most of you will now logically arrive at the same conclusion. Let me share the following with you. Which came first, the Constitution or the statutes?
Oh, I thought you were going to be chicken and egg.
Here in Michigan, our Constitution was adopted in 1835. Our enacted statutes were called the Revised Statutes of 1846. a full 11 years after our state constitution. So for 11 years, we had strictly common law, the people's law. Here is some interesting trivia that will provide some insight into how we can discern where the real authority is. When dealing with what is lawful and what is merely legal, ask yourself who or what organization enacted the rule or regulation. If the people at large wrote it, then it is lawful. However, this would be the federal or state constitutions. However, if elected officials, elected public servants wrote or enacted the rule or regulation, it is called a statute. It is merely legal, and that means it is not constitutional law, but statutory law. Now, this is very important. There is a huge difference between what is constitutional law, something adopted by the people, and what is statutory law, and that is something enacted by elected public servants. We don't get to say that phrase often enough. Give it some thought. Elected public servants. They serve us. Thank you. The overriding fact here is that we, the people, believe that all men, being mankind, I don't want to shorten any of the ladies, are created equal. And no man or woman can order another man or woman to do anything. Give this some thought. If I, as either an elected or unelected man, cannot order my neighbor to do my bidding, a group of my friends cannot by a vote order my neighbor to do our bidding. We will try to find within our Constitution how a statute came to be thought of as having this authority. Keep in mind that what we find may not be the support of what we have been led or programmed to believe. Let's stop here, and I'll start bringing to your attention some evidence to back up my opinions and assertions. I'm going to start with the Michigan Constitution. We see at Article 1, Section 1, something that we all need to memorize. But first, let's look at the preamble to our Constitution. It is as follows. We, excuse me. Thank you, Sally. You are a doll.
It is.
Preamble to the Michigan Constitution. We, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom and earnestly desiring to secure the blessings undiminished to ourselves and our posterity, do ordain and establish this Constitution. Important words. Now, let's get to the heart of the subject. That is the first article of the Michigan Constitution at Article 1, Section 1. It is first for a good reason. It sets the stage for the rest of the document. It's entitled, Section 1, Political Power, as follows. All political power is inherent in the people. Government is instituted for their equal benefit, security, and protection. One simple little sentence, but it's very, very powerful.
Say it again.
I will. All political power. Now that is an important word, political power. What is the only power we allow the state to wield? political power. We loaned our authority to our state public servants to regulate our state. And I'm going to say that very few public servants have read that and understand what it says. Let me start once again because Sally is at a good point. Article 1, Section 1. All political power is inherent in the people. It belongs to us. We are absentee landlords. We elect people who know probably less than we do, and they are assuming authority over us. All political power is inherent in the people. Government is instituted, another word, created. We created government for our mutual and equal benefit, security, and protection. I don't want to dwell on this too long, or I'll have you guys here all evening, and I'll have to provide lunch.
John, we're gonna have to, we have people coming to the house, can we get a copy of that?
I'm gonna make sure that I make a copy of this available to everyone. You'll just get my email address, you'll send me an email, and I'll forward this.
Okay.
And it's being recorded, so it's gonna be available to you on the internet. So not a problem, I appreciate you staying as long as you did.
Thank you.
Below I've researched on the internet some of the words and phrases used. Here's what I found. What is political power? The answer, in social science and politics, power is the capacity of an individual to influence the actions, beliefs, or conduct, which is behavior, of others. What are some types of political power? Answer, there are three basic sources of power: force, influence, and authority. Some common synonyms of power are authority, command, control, dominion, jurisdiction, and sway. While all of these words mean the right to govern or rule or determine, power implies possession of ability to wield force, authority, or influence. Inherent. It's an adjective, existing in something as a permanent, essential, or characteristic attribute. In law, vested in someone as a right, an authority, or a privilege. The people declared in our preamble that they had the power and authority to establish our Constitution, so only they have the power and authority to make changes and are exempt from any subservient agencies, statutes, or ordinances. As all men are created equal, none may assume the power and authority to order another man. I'm going to fill in what should be some thoughts going around in each and every one of your minds. Our state, our county, our townships order us around and regulate us every day. Do they have that power? Let's find out. So what does all this power and authority give us? Well, it protects us by our declaration within the Bill of Rights and our own state's Declaration of Rights. A few of the important ones are as follows. Michigan Constitution, Article 1, Section 6, bearing of arms. Every person has the right to keep and bear arms for the defense of himself and his state. Article 1, Section 2, equal protection. No person shall be denied the equal protection of the common laws, nor shall any person be denied the enjoyment of his civil or political rights or be discriminated against. I'm going to skip the rest of it, it's lengthy. I highlighted the word common before the word law due to the way the word law is used in an ambiguous way. See section 3, article 3, section 7 in our Constitution. It says as follows: the common law and the statute laws now in force, not repugnant to this Constitution, shall remain in force until they expire by their own limitations or are changed, amended, or repealed. So the people get the common law, but it says our state has two separate and distinct styles of law. So who gets statutory law? I direct you to MCL 8.3L. In the Michigan compiled laws, the statutory laws, here is another place where the word law is very misleading, as we find out who is liable to statutory law. Chapter 1 of the statutes, revised statutes of 1846, 8.3L, person defined. The word person may, which equals shall, extend and be applied to bodies, politic and corporate, as well as to individuals. At this point, I will caution everyone hearing this to ask the question, when hearing the term, individual, ask individual what? The word individual is an adjective describing how many of something. It may refer to cars, trucks, or men, unless we know for sure. Do not assume anything. We have found who is liable to the statutory law. It says anywhere in the statutes that the word person is used, that is who is liable. The two groups of persons or entities that can cause or do the most damage to the people are defined here. Bodies politic are anyone who is elected or appointed and receives pay from the people's treasury. They have the opportunity to mismanage or be corrupt in their employment as public servants. While the corporate are the commercial entities who ask to sell the people something. It lets us keep them honest in their business. It is a good time to see if you have been listening. Which would you rather be? A man or woman known as the people and get common law with constitutional protected rights, or a statutory person who does not get common law, only statutory law, which can be found in our Constitution at Article 1, Section 17. Article 1, Section 17, titled Self-Incrimination, Due Process of Law, Fair Treatment at Investigations. No person, now this is a legal word ploy. In the Constitution, it is supposed to be written at an 8th grade level. They use the word person in the Constitution to mean the people. And that same word has been appropriated into the statutes to mean something totally different. So let me continue. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Now, this second sentence was added to the 1908 Constitution. And I think we can see why it was added. It says the right of all individuals, remember this word, firms, corporations, and voluntary associations to fair and just treatment in the course of legislative and executive investigations, and hearings shall not be infringed. That second sentence says individuals, firms, corporations, and voluntary associations do not get something that's very important. They do not get constitutionally protected rights. They get something called fair and just treatment. So there you have it. Persons, the people, get common law, which is the Constitutional Declaration of Rights, including the big one, due process of law. From the first sentence. The second sentence states that individuals, here's that word again, firms, corporations, voluntary associations only get something called fair and just treatment, whatever that is. So what ties this all together? It is our good friend, the oath of office. I bring to your attention Article 11, Section 1, that reads, State Constitution, Section 1, oath of public officers, public servants. Officers is sometimes too nice of a word for what I'm going to show that they do. All officers, legislative, executive, and judicial, before entering upon the duties of their respective offices, shall take and subscribe to the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully, having faith, discharge the duties of the office of blank, according to the best of my ability. No other oath, affirmation, or any religious test shall be required as a qualification for my office or public trust. Now that covers all offices of the three branches. And not to leave any stone unturned, we have the statute that covers anyone else that is receiving money from the people's treasury, located at MCL 15.151, which reads as follows. Section 151 or 15.151, title is Constitutional Oath of Office, Employees and Persons in Service of the State. All persons now employed or who may be employed by the state of Michigan or any governmental agency thereof, and all other persons in the service of the state or any governmental agency shall, as a condition of their employment, take and subscribe to the oath or affirmation required of members of the legislature and other public officers by Section 2 of Article 16 of the Constitution of 1908 of the state of Michigan. Basically, what I just read you for in our Constitution. Remember, this is a statutory law that every person in the statutes must follow. Every law enforcement officer, every village, city, county elected or appointed public servant, obviously every state public servant. They must obey the Constitutional Declaration of Rights and statutory laws from the oath of office they took. If they disobey them, they are guilty of violation of their oath of office, violation of misconduct, violation of the Constitution that they swore to protect and defend.
Is this school board?
If they get public money from the public treasury, guess what? They better have an oath of office on file, and they better understand what it means. Law enforcement officers that pull you over because you have no plate, tag, or plate at all must provide proof of all the elements of the statutory civil infraction that he is accusing you of breaking. If you are not found to be one of the persons defined at Michigan compiled laws, statutes 257.40, and you declare yourself to be a common law man and one of we the people mentioned in Article 1, Section 1, then he must be trained to understand that you are not liable, and furthermore, you are exempt from all statutes. While he or she is guilty of a much more serious violation of your federal and state protected rights, along with the federal offense of USC, United States Code, Title 42, Section 18, or 1983, Title 18, Section 241, and Section 242. Title 42 U.S. Code, 1983. Every person, law enforcement, public servant, who under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof. So they've made a distinction. So there's a difference between citizens of the United States or other persons within the jurisdiction thereof to be deprived of any rights, privileges, immunities secured by the Constitution and laws shall be liable to the party injured in an action at law.
I have a quick question.
Yes,
So when they pull you over and accuse you, that is.
they just violated your right.
And
Unless
it's a federal offense for them to do that under the Constitution?
it just says so right here.
Oh my gosh.
Yes, why are we so ignorant? Believe me, the Lord laid it upon me over the past 5 or 6 years to put this together. The ramifications of this are going to be astounding. Brought against let's see, or any other proper proceedings for redress except in any action brought against a judicial officer for an act of omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaration decree was violated. It gets a little lengthy, but you get the idea that you have, if you cannot get your rights addressed at the scene, I've taken these things, mostly what I do is I go to the prosecuting attorney and we have a talk. And he understands, once we've had a talk, that generally this, whatever action gets dismissed.
So some county officials just, they don't
They're-
like you.
Oh, I'm not necessarily
And they're
popular in their
yeah.
venue, but like I say, I am just starting to educate my brothers and sisters.
Opening our eyes.
And yes, very much so. Now, what do you win in a 1983 case? How do you win in a 1983 case? To prevail in a claim under section 1983, the plaintiff must prove 2 critical points. The person subjected the plaintiff to conduct that occurred under color of law. There actually are persons, statutory persons, who are under the motor vehicle code. Bodies politic, anybody that is a public servant, and corporate people. They actually have to, that taxi driver, he's got to obey each and every one of those traffic signs. We all should obey those traffic signs because we don't want to make accidents.
Right.
But we can't be held liable unless you create an accident, and then you are liable under common law, not statutory law. So 2 things. You must plaintiff to conduct that occurred under the color of law. So the color of law here is, if you're not a statutory person, they're using a law against you that you're not liable to. That's color of law. Misrepresentation. And this conduct deprived the plaintiff of rights, privileges, or immunities, i.e. that $100 you gotta pay, that's a property you're being deprived of. There is no statute of limitations within the language of 42 USC 1983. Remember, no one can order a law enforcement officer to violate the law. If his sergeant or somebody tells him to go out and enforce the statutes, that sergeant or his supervisor better train him who is liable and who is not. Because not only is the officer liable, now his sergeant is liable, or his boss, or whatever agency he's working for. They call it collusion.
Not that word.
So under constitutional law, they would all be violating the Constitution.
They're ignorant, yes. They are violating their own constitution they were sworn to
Of the
protect.
state that they were sworn, yeah.
Remember, no one can order a law enforcement officer to violate the law if he or she has not been trained to make sure that he has a person and not a man or woman going about their daily chores. Then he and his supervisor and the agency that employed him will be sued. One more point I want to make is this. I know, thank God. In my research, I found that not only our state, but most others have looked at the use of the same wording and tactics to keep the inhabitants under control and ignorant of their true power and authority. Florida, the 2021 Florida Statute 1.01 definitions. In construing these statutes and each and every word, phrase, or part thereof where the context will permit. Section 3, the word person includes individuals, children, firms, associations, joint adventures, partnerships, estates, trusts, business trusts, syndicates, fiduciaries, corporations, and all other groups or combinations. Now, you go to Florida and you get a ticket. Which one of the above are you? If you request it, the officer will have to prove which one you are. Are you an individual? What do we know about individuals? What is the question we asked when we heard the word individual? Individual what? Individual children? No, not a children. Individual firm, individual association, joint adventure, partnerships, estates, trusts, you get the idea. That's what you want to ask that officer. In Michigan, you ask him, there's 4 things. Our statutory definition of person is at MCL 257.40. Says an individual, or says a person is a firm or a natural person. I get to that. Firm, co-partnership, association, or corporation, or other individual. Whenever you hear the word individual, you ask, individual what? They can't tell you. So, a driver, another interesting word. Are you a driver? Driver definition. Any person who drives or is in actual physical control of a vehicle on a highway, or who is exercising control of a vehicle or steering a vehicle being towed by another vehicle. Section 53, an operator. Definition of an operator. Any person who is in actual physical control of a motor vehicle upon the highway, or who is exercising control over a steering or steering a vehicle being towed by a motor vehicle. I verbally italicized some of those words. They're important. 54, owner. A person who holds the legal title of a vehicle if a vehicle is the subject of an agreement. I will get the idea. And 57, remember, we're still in the Florida Motor Vehicle Code. Person, any natural person, firm, co-partnership, association, or corporation. Okay, give you a quick rundown. Ohio Motor Vehicle Code. Oh, section W, a person means every natural person, firm, co-partnership, association, or corporation. Get the theme here that this is multi-statewide.
They're copycatting.
It all come from a big higher authority that said, we're not making enough money.
So what is a natural person?
I'm glad you asked that. In most of the states, there is an interesting choice of words here in their motor vehicle code, which is, number one, natural person. And the next is the word vehicle. They are both defined, and yet they are misrepresented in the code to be vague and misunderstanding. When you understand the proper definition of these words, you will see why they are used. I will provide you with the best possible way to decode this phrase that we have found. Look up the construction of statutory laws or statutory construction, and you will find two important items. One of these is that where two or more items are mentioned, they must all be in the same group. Anybody ever see some of these things are like the others?
And Sesame Street, yeah.
Sesame Street, thank
Sesame
you.
Street, yeah.
So they must all be the same thing. And the second is that what is not mentioned is left out on purpose. So where we have the term natural person, it's mentioned along with firm, co-partnership, association, or corporation. As these are all legal entities, we must infer that a natural person is also a legal entity, not a man or a woman. Now, a legal entity is a taxi driver, someone that drives for a living to make money on the public highways. You must meet those elements to be guilty of that infraction. If you're going to the grocery store, you're not making money. Unless your significant other gives you $20 to go get groceries, that don't happen. As these are legal entities, we must infer they are natural persons and not a man, but a legal entity. And also using the second part, as a man or woman is not made liable in the statutes. Why didn't they say man or woman? Let's go back to Article 1, Section 1. Who is ultimately the power and authority in every state? The man and or the woman. They are people. The public servants that wrote this cannot make their boss liable. That's like your maid giving you the dickens for messing up the house. No, they're paid to clean up the house. Okay, so I could go on, but you get the idea. If you are interested, please do some of this research yourself. I've provided you with 20 years of experience. I wish I would have known this 20 years ago.
Look at the last page.
Be advised that some portions of this presentation have been copyrighted, and authority to use these portions need authority of the author. Now, I have turned this into a Testimony. I have had it notarized. I have went and had it notarized. So this can be used in each and every court of law, the people's law, common law, and or statutory law. Now, if I can have just one more of your minute, just one more minute of your time before you guys want me to provide lunch. I knew I was gonna take this long, I would have brought something. I have found an interesting, now, this is, my forte is the Michigan Motor Vehicle Code. 20 years ago, or longer, I've got to admit, I got a couple civil infractions. But I was led to believe in elementary school, junior high school, college, that, gosh darn, you know, I have the right to travel. I have a constitutional right to travel. I have a statutory right to travel. I have a state right to travel. How can I maybe do a rolling stop where no other cars are around and get a ticket for that? Well, it didn't take long to figure out that under common law, the state doesn't make much money, but under statutory law, they seem to do pretty good. So there's motor vehicle code. There's why the motor vehicle code exists, and it's enforced so well is money. So how about some of the other ramifications? Anybody ever pay a, let's say, sales tax?
Oh, yeah, every time.
Gosh, yeah, interesting. They have something they call an enactment clause. Every statute has got to have the reason that it's in existence, that the act was deemed necessary to put it in existence. Now, I went to the enactment clause of the General Sales Tax Act 167 of 1933. An act to provide for the raising of additional public revenue. I highlighted additional public revenue by prescribing certain specific taxes, fees, and charges to be paid to the state for the privilege of engaging in certain business activities. When you pay a sales tax, you are deemed to be in business. So when you bought those crayons, when you bought your car, you are deemed to be in business by the General Sales Tax Act. This provides incident to the enforcement thereof for the issuance of licenses to engage in certain occupations, to provide for the ascertainment, assessment, and collection thereof. Anyway, just one other sentence. So how can the state, now the provisions of the general sales tax do not allow for the retailer who is in business. It says there's no provision in here to pass that along. That is a cost of doing business, and yet it's passed along to each and every one of us. Guess what, guys? It is unlawful. It is illegal. It is a violation of our rights. We don't owe a sales tax to be paid to the state for us being men and women and buying the products that we want to buy. I want you to think about that. I have, in the interest of time, I want to cut this short. I will just bring to your attention some additional research that each and every person should do. State income tax.
Oh, Lord.
So by being Let me read the first sentence here. An act to meet the deficiencies of state funds, deficiencies, overspending. I know if I have a deficiency in my budget, I spent too much. By providing for the imposition, levy, computation, collection, assessment, reporting, payment, and enforcement by lien or otherwise on taxes on or measured by net income on certain commercial business financial activities. So when you voluntarily pay your state income tax and possibly federal, but you didn't hear me say that, you are telling the state, or they're forcing you to tell them, that you are a certain commercial, business, or financial activity. And with that, ladies and gentlemen, I conclude this first presentment of the difference between constitutional and statutory laws. Thank you. Now, is there any questions that I might answer? Have a good one,
No,
Brian.
no, I have a question.
I like the part about obey the signs, but you're not
You
liable.
can have a copy of this and
Yeah.
we'll discuss it. You know
Copy
it.
of it.
Yes,
Okay, I worked, I paid my dues, so to speak.
yes, you
I'm
did.
on disability.
Yes,